ಹಲೋ. ಹಲೋ.
Alapnaur? Hello? Hello, Manjunath? Hello?
Yes, sir. Yes, sir.
Guest
Yes, sir.
guest join ಆಗ್ಯಾರು?
Yes, sir.
Guest join ಆಗ್ಯಾರು?
ಹಾ ಸರ್, ಇನ್ನೂ ಇಲ್ಲ ಸರ್.
ಆಯ್ತು. ಓಕೆ ಓಕೆ. You called him? Manjunath?
Yes, sir.
ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇಲ್ಲ, ಬ್ರೇಕ್ ಆಗ್ತಾ ಇದೆ ನೋಡಿ.
ಸರ್, ರಿಸೋರ್ಸ್ ಪರ್ಸನ್. ಹಲೋ.
ಹಲೋ.
ಹಲೋ. ಹಲೋ.
ಹಲೋ.
Sir, am I audible?
Yes.
Yes.
Yeah, you are audible.
ಇಲ್ಲ ಇನ್ನೂ ಜಾಯ್ನ್ ಆಗಿಲ್ಲ.
ಸೊ ಫೋನ್ ಮಾಡಿ ಕೇಳಿ ಅವ್ರಿಗೆ.
ಮಾಡ್ತೀನಿ ಸರ್, ಒಂದು ನಿಮಿಷ. ಮೈಕ್
Yes. Chandni, hello.
Sir.
Chandni,
Sir.
yeah. Keep yourself ready. The resource person will join within 5 minutes. We
Okay.
have to begin sharp at 3 o'clock.
Okay, sir.
Okay.
Yes, the guest speaker joined. Manjunath.
Sir, not yet, sir. He said in 5 minutes he will join.
Okay, okay. I'll just welcome him and wish him and leave because
I'll let you know, sir. I'll let you know,
our
sir.
meeting also.
Yes. Chani,
Yes, sir.
yes, you can begin.
Okay, sir. Good afternoon, sir.
Yeah.
Yes.
I, Ms. Channi R. Mokashi, a third-year BA LLB student of KLE's B.V.Bellad Law College, Belagavi, would like to welcome all the participants to this third day of national webinar being conducted by our college on the topic Alternative Dispute Resolution System. KLE's B.V.Bellad Law College is situated in the city of Belagavi, Karnataka. It was established in the year 1975. Since then, it has been imparting legal education to 3 years LLB as well as 5-year BLLB courses. May I now request respected principal of our college, Dr. B. Jayasimha sir, to address the gathering. Sir.
Yeah. Yes. Thank you, Chandani, for that opening the session. At the very outset, I welcome all the participants once again to the third day of this national webinar series on the topic arbitration, alternative dispute resolution system, an effective mechanism for resolving the disputes outside the court. We have an eminent speaker today, Mr. Shri Chirag Balyan, is the coordinator for Arbitration and Research Center of MLLU, Maharashtra National Law University, Mumbai. I welcome him and thank him for his precious time for sparing for us and sharing his knowledge with all the participants today on a very important topic of alternative dispute resolution. During the last two talks, we heard about the negotiation and about the mediation from the eminent speaker. Today, the speaker will be dealing with the fundamentals of arbitration. Hope there will be a complete enrichment of the knowledge on the topic to all the participants. I wish the talk will be very pleasant and help the participants and all the professors and all the teachers, all the students who have participating in this national level webinar will return back from this webinar with a lot of fond memories. And I wish to inform you that we are doing this exercise as a part of our IQAC International Quality Assurance Cell, and we are continuing with this with our next webinar coming on 24th of this month on the topic sexual harassment against the children with the special reference to POCSO Act, where Professor Dr. M.K. Matulli will be addressing and analyzing the POCSO Act to all the participants. The link will be shared shortly. Kindly do join for that webinar also and help us in growing with the academic exercises that we are doing. Also, see that the webinar becomes successful. I wholeheartedly welcome Chirag Balyan, who has kind enough to accept our invitation today. And I have a small submission. As today I have to attend one more online meeting of our Karnataka State Law University Hubballi, where we have got the students grievance committee online committee meeting. And I, being the syndicate member of Law University, my presence in that meeting is very important to answer the grievances put down by the students of various law colleges. So I'll be leaving this seminar and hopefully join after the meeting is over and join you all this webinar. So with this opening remarks and once again, I welcome you all to this webinar. I kindly excuse me for leaving this webinar here. Also, Mr. Chirag Balyan, if you are listening me, I once again very profusely thank you for sparing your valuable time for us. Thank you. Wish you all the very pleasant learning of the topic in the national webinar. Thank you.
Thank you so
Yes,
much.
Chandni.
Thank you so much, Dr. Jaisima, for giving me this opportunity.
Thank
It is my sheer privilege
you.
to
It's my
interact
pleasure.
with our students and the other participants who have joined in this
Yes.
3-day national webinar series. I'm really looking
Yes,
forward.
yes.
I can understand that you have prior commitments.
Yeah.
And
Yes.
please,
Huh?
I'll
Thank you. Huh? It's very kind of you. Very kind of you.
Sure.
Right.
Yeah, Chandni.
May I now request Priya Swami ma'am, Assistant Professor of our college, to introduce the resource person of today's webinar. Over to you, ma'am.
To introduce the eminent resource person of this national webinar series on alternative dispute resolution systems, Shri Chirag Balyan. Sir is an assistant professor of law at National Law University, Mumbai. He is coordinator for Arbitration Center and Maritime Law Center at National Law University, Mumbai. He is also the Deputy Director of Research Center in Criminal Justice at National Law University, Mumbai. Sir is recently entrusted with the task of coordinating India's first master's degree in mediation and conflict resolution at Mumbai. Sir is actively involved in the training of judges, lawyers, corporates, police officials, and law students on various areas of law. He has numerous publications to his credit. He co-edited book titled Revisiting the Reforms in Criminal Justice System in India is all set to be published by Thomson Reuters. With this brief introduction, once again, I, on behalf of Kaili Society's B.V.Bellad Law College, Belagavi, welcome the resource person of today's session, Sri Chirag Balyan, Assistant Professor of Law at National Law University, Mumbai. Welcome you, sir.
No.
And we are very eager to listen to the insightful words of you, sir. Over to Chandani.
Over to you, sir.
Over to you, sir. Please start.
Sure.
Yes.
So once again, I thank B.V.Bellad Law College, management of college, principal Dr. Jai Sinha, Professor Srinivas, with whom I have been coordinating, and all the other distinguished faculties at the college. A very good evening to one and all. Before I start further, I would like to appraise the organizers that I have a PPT. Can you give me host rights so that I can present it on my screen? I think I can do it. Give me a second. Yes. I hope all of you can see the PowerPoint presentation. It's there in front of your screen.
Yes, sir. Yes, sir. It is visible.
Thank you so much. Thank you. So today I'm going to talk about fundamentals of arbitration law. Now, I'm very happy that before my session, all of you have already covered and understood about the two major aspects of alternative dispute resolution, which is mediation and negotiation. Arbitration is another aspect of alternative dispute resolution. Now, what we need to know about arbitration, and especially arbitration in India, is that arbitration in India is governed by Arbitration and Conciliation Act 1996. This legislation of 1996 is based on UN Citral Model Law, United Nations Commission on International Trade Law Model Law of 1985. It has been recently amended in 2015 and 2019. Now, presently, to deal with both domestic awards and as well as foreign awards, we have one single legislation of 1996. But before the legislation of 1996, we had three legislations governing arbitration in India. One was the Arbitration Act of 1937. Second was Arbitration Act of 1940. And third was Enforcement of Foreign Awards 1961 legislation. So before the 1996 legislation or before the 1996 regime, we had three separate legislations governing arbitration in India. While 1940 legislation governed the domestic arbitration or the Indian arbitration, the 1937 legislation and 1961 legislation dealt with foreign award. 1937 was primarily concerned with awards rendered under Geneva Convention, which was enacted in 1923, and awards passed in 1961 legislation were made pursuant to the New York Convention of 1958. So this brief historical background of 1996 legislation, all of you need to know. Now, what had happened in 1996, domestic arbitration is covered under Part 1. So domestic award, Part 1, which is sections 1 to 43. Thereafter, Part 2 of the Arbitration and Conciliation Act deals with foreign award. So foreign award presently are rendered under two international conventions. First international convention is Geneva Convention, which had a separate legislation in India, 1937. And second is the New York Convention, a 1958 convention, which was enacted separately in 1961. Now, both 1937 legislation and 1961 legislation are clubbed in Part 2 of the Arbitration and Conciliation Act. And from Section 44 to Section 60, there is entire gamut of foreign award. Thereafter, there are two more parts of this law, which is conciliation. Conciliation is very similar to mediation, but if you refer to the judgment of the Supreme Court in AFCON International, they have identified certain distinction between mediation and conciliation. That is not the subject matter of today's discussion. Those who want to read more about conciliation and its distinction with mediation can read the judgment in AFCON International case of the Supreme Court. Thereafter, there are certain supplementary provisions between sections 82 to 87, and that's the Part 4 of the Arbitration Act. Apart from 87 section, there are also 8 schedules. In these 8 schedules, draft text of the Geneva Convention, the text of New York Convention, what should be the model fees, what should be the qualification of arbitrators, what should be eligibility of arbitrators, under what circumstances can we say that arbitrator is neutral, under what circumstances can we say that arbitrator is impartial. So all these 8 schedules are also appended to the legislation of 1996, which governs all these areas. So this is the brief background of the Arbitration and Conciliation Act, which you need to understand before we move to the next stage. Now, if any one of you has any question on this aspect, please let me know. Otherwise, I'll move to the next slide. Any question? Okay. So here I must also explain one thing. Now, when we talk about arbitration in India, arbitration in India can be between 2 Indian parties. In that circumstance, part 1 of the legislation will apply. That is section 1 to 43. So if the arbitration is between 2 Indian parties, both the parties are Indian, then such award which is passed by an arbitrator is called domestic award. First situation. Second situation is one party is Indian and the other party is foreign. There is some foreign national or a foreign corporation. Say there is a dispute between Reliance Industries and Amazon. Reliance Industries is an Indian party. It's an Indian incorporated company. Amazon is a US incorporated company. It's a company registered in United States. And both the parties decide that the arbitration shall be conducted in India. The seat of arbitration, I must explain this term seat at a later point of time. The seat of arbitration must be in India. Even then, an award rendered in such arbitration shall be deemed to be a domestic award, and part 1 of the Arbitration and Conciliation Act 1996 apply. So this is what we can domestic award, or in part 1 we can say we can have domestic arbitration between 2 Indian parties, and we can also have international commercial arbitration. When one party is Indian and the other party is foreign, then we can say it as international commercial arbitration. But as far as international commercial arbitration is concerned, if the seat of that arbitration is in India, if the place of that arbitration is in India, it will be governed by part 1 of the Arbitration and Conciliation Act 1996. But if in the international commercial arbitration, the seat of arbitration is any other country than India, then part 2 of Arbitration and Conciliation Act 1996 will apply. Let me explain you with the same example. The case between the Reliance Industries and the Amazon is one that of an international commercial arbitration, because one party is Indian party and the other party is a foreign party. Now, if both these parties decide to conduct their case, or if the seat of arbitration in this case is India, then we say part 1 of the Arbitration and Conciliation Act 1996 will apply, and the award rendered by an arbitrator will be deemed to be a domestic award. But when we say that there are 2 parties, one Indian and one foreign party, Reliance Industries and Amazon International or Amazon, and both of them decide that the arbitration should be conducted in Singapore, then part 1 of the Arbitration Act will not apply, part 2 of the Arbitration Act will apply. Part 2 will become applicable. Now, if this award is to be enforced in India, then we will apply the provisions of part 2. So this important distinction you must understand. Now, let me ask you a question so that I can ascertain that you have understood this point. There is a case between Paytm which is a popular e-commerce company incorporated in India. And on the other side, you have other party as Mercedes, which is a company incorporated in a country other than India. And both these parties decide that arbitration shall be conducted in London. Then which part of Arbitration Act will apply? Can anyone answer me this question? Hello? Anyone? Okay. So even in this circumstance, we have to say that this is an instance of an international commercial arbitration with a foreign seat, because India is not a place where this arbitration will happen, and this arbitration will happen in a foreign country, and therefore part 2 of the Arbitration and Conciliation Act will apply. Now let's move to next slide, which is fundamental concepts. Now there are two kinds of arbitration: ad hoc arbitration and institutional arbitration. Let me first explain you what is institutional arbitration. Arbitrations which are conducted under various institutional rules are called institutional arbitration. Now, what is institutional rules? There are various arbitral institutes. So, for example, in Mumbai, there is Mumbai Center for International Arbitration. If an arbitration is conducted as per MCIA rules, then that arbitration is called institutional arbitration. Similarly, in Bangalore, we have Nani Palkhiwala International Arbitration Center. So if arbitration is conducted as per the rules of Nani Palkhiwala International Arbitration Center, then that is also referred as institutional arbitration. Similarly, we have Arbitral Institute in Delhi, New Delhi International Arbitration Center. We have similar kind of institutional arbitration centers in various parts of the world. Say in Singapore, we have Singapore International Arbitration Center. In London, we have London Court of International Arbitration. In Hong Kong, we have Asian International Arbitration Center. We have Beijing International Arbitration Center. So parties may decide that they want to use the services of which institute while conducting their arbitration. And depending upon which institute they choose, the rules of that institute will apply. On the other hand, ad hoc arbitration is an arbitration where the parties themselves decide that how their arbitration will be conducted. That is, there is no institutional support. Arbitration is conducted by the parties themselves. Arbitration is conducted by the parties themselves. So this is first major distinction you must understand between ad hoc arbitration and the institutional arbitration. Thereafter, we have this concept of arbitration agreement. Now, what is arbitration agreement? Arbitration agreement is an agreement between the parties by which the parties decide that in case a dispute arises between them, then that shall be decided by way of arbitration. Now, generally in India, the default way of resolving the dispute is by way of litigation. So if there are any disputes or controversies between the parties, they will approach the court. They will go through the litigation. In that case, there is no requirement of an agreement between the parties. If there is a dispute, say there is a case of the dishonor of check under section 138 of the Negotiable Instrument Act, and the check bounce. Now it is a dispute. For that, if one party wants to go to the court, no agreement is required. But because arbitration is a special procedure, it is provided in the Arbitration and Conciliation Act, section 7, that there shall be an arbitration agreement between the parties. If the parties don't have an arbitration agreement, they cannot resolve their dispute by way of arbitration. So an arbitration agreement, which should always be in writing. Now, arbitration agreement is also like a contract. Now, contract can be by oral terms, it can be in writing, or it can be by conduct also. But arbitration agreement recognizes only written contracts, and therefore any such arbitration agreement which confers the rights upon the parties to raise the dispute before an arbitrator must be in writing and must be backed by an arbitration agreement. So the concept is defined in, and what are different kinds of arbitration agreement. You can read about it in section 7. Thereafter, we talk about another important concept, which is called arbitrability. Now, what is arbitrability? Now, if any dispute arises between two parties, that can be taken to the court of law, either civil court or a criminal court. If a special tribunal is provided, like for consumer forum, say rent tribunal or say service tribunal, then you can approach those respective tribunals, right? But any and every case can be taken by the courts. But this is not a case in arbitration. An arbitrator cannot entertain every kind of dispute. There are certain limitations upon the power of an arbitrator. These limitations exist because arbitrator, unlike a judge, is not appointed by the High Court or the state government. Arbitrator is appointed by the parties by way of a contract, and therefore the power and authority of an arbitrator comes from the contract. It is derived from the contract. And therefore, you cannot give every possible power to an arbitrator to resolve all kinds of disputes. For example, criminal matters cannot be decided by an arbitrator. So we can say that criminal matters are not arbitrable. Similarly, those matters wherein special tribunals have been provided by the legislature, like consumer courts, like company court, like debt recovery tribunal. In all those cases, also an arbitrator cannot have a jurisdiction. An arbitrator cannot decide any dispute between the consumers. Insolvency disputes, if the matter pertains to an insolvency of a company, that cannot be decided by an arbitrator. So the entire concept is called arbitrability. That is, what can be decided by an arbitrator and what cannot be decided by the arbitrator. If I have to generalize this concept in a very broad term, but not absolute term, I can say disputes which affects the right in rem cannot be decided by the arbitrator. An arbitrator can only the disputes which affects the right in personam. Disputes which affect right in rem means which will affect the right against the whole world. Now, let's take an example of a divorce petition or a divorce petition between the husband and wife. Now, any decision passed by an arbitrator with respect to the divorce of husband and wife will just not affect these two individuals, that is husband and wife. It will also affect the society at large. It will affect because it pertains to the status of the parties. Status as in husband and wife. The decision of the arbitrator will affect the status. And therefore, such kind of disputes cannot be decided by the arbitrator. There is lot of controversy whether IPR disputes pertaining to intellectual property rights, can they be decided by the arbitrator? The opinion is divided. In India, we say that certain kinds of intellectual property disputes, which are contractual disputes, say pertaining to licensing, whether copyright was licensed or not, whether right to use trademark was given to the other party or not. These are contractual disputes or disputes pertaining to licensing or royalty. These kind of disputes can be decided by the arbitrator as per the judgment of the Bombay High Court in IPRS case. But disputes pertaining to grant of intellectual property, like grant of patents or annulment of patents or rejection of patents, grant of copyright or annulment of copyright cannot be decided by an arbitrator because the decision of such disputes will affect the society at large and not just the parties. This is called the principle of arbitrability. Thereafter, this is the most important concept, and this is the biggest reason why parties choose arbitration. And this is party autonomy. Now, what is party autonomy? Party autonomy means parties have I think there was some technical error. So, what is party autonomy? Party autonomy means that parties have the right to decide who shall be their arbitrator. Now, in ordinary litigation, you cannot decide who should be your judge. And it is for this reason people choose arbitration, because they can mutually decide who should be the arbitrator. Now, while deciding who should be the arbitrator, they have various considerations. Say a dispute is a very technical dispute. In that circumstance, what we can say is that we need a person having a sound technical knowledge. Now, you don't know that when you file a case in the court by a litigation, you will get a judge who is having the sound technical know-how of that industry. Say there is a construction dispute as to the quality of material used in preparing one particular bridge. Now, the judge may not have the know-how or may not have an understanding of the construction industry or what kind of material or construction material is good enough for building a bridge. He may decide the dispute legally, but deciding dispute also requires certain technical knowledge. And therefore, by virtue of the principle of the party autonomy, parties can decide who shall be their arbitrator and accordingly that person. So it is not required in arbitration that arbitrator should be a person from a law field. An arbitrator can also be an engineer. If the dispute pertains to some financial issue or some accounting issue, you can also have chartered accountants or chartered financial officers to resolve your disputes. Many a time you may have a politician or even a spiritual leader resolving your dispute pertaining to arbitration. So, as far as the qualification is concerned, there is no bar as such. A person from any field can become an arbitrator. The only requirement is the parties must repose the trust on that person. If the parties have reposed the trust, they can. So, first party autonomy extends to choosing who can be their arbitrator. Secondly, parties by virtue of their party autonomy can decide what should be the law applicable to them. Now, generally when we say what should be the law, if there is one Indian party and one party from London, then there will be a constant strife between them. There will be a constant controversy between them that the law of my country should apply. As an Indian party, I would say that the law of India will apply. As a party from London, he would say law of my country will apply. Now, if these parties in transnational dispute keep on fighting that what should be their applicable law, then they will not enter into any kind of business because there will be a mistrust. They would be just fighting and it will affect the overall economy of the respective countries and it will also affect the global trade. In order to resolve such kind of issues, both the parties may decide neither your law nor my law. So neither we will use England law, neither we will use Indian law, we will use the law of Singapore because that is a neutral law. Neither you can say that that law benefits you, nor I can say that that law benefits you. So what you get as a benefit in arbitration is freedom to choose your law. You can expressly say in your arbitration agreement that in this dispute, the law of Singapore shall apply, in which case Singaporean law will apply. Now, when I'm talking about applicability of law, all of you must distinguish between two kinds of laws. First is law of contract, and second is law of arbitration. Now, law of contract to resolve the dispute and law of arbitration to resolve the disputes may be different. I may say that the law of contract, which will be applied to resolve our dispute, will be law of Singapore. But I can at the same time say that the law of arbitration to decide various issues pertaining to arbitration shall be Indian law. Parties have this freedom of choice, but this freedom of choice is not applicable if you have decided that the Indian courts have jurisdiction, then the Indian law will apply entirely. In litigation, you cannot exclude the applicability of Indian law. मैं आज यहाँ बैठा I am sitting here cannot say that the Indian law will not apply to me. I cannot do that. If a party has filed a case against me, then I have to be bound by the Indian law. But that's not the case in international commercial arbitration, where the parties are of different origin, where they may not have a consensus on what law should apply. In such circumstances, they may say, let's agree on a neutral law. When I say substantive law or when I say contract law, it means the rights, obligations, and the liabilities of the parties will be decided as per Singapore law. When I say that the substantive law is the contract law or law of contract is as per Singapore law, it means rights, liabilities, and obligations are to be decided by the Singapore law. When I say that arbitration law, or what we refer in Latin as lex arbitrae, is Indian law, that means how arbitrators should be appointed, how arbitrators should receive the evidence, how matters pertaining to confidentiality, how matters pertaining to impartiality, how matters pertaining to setting aside of award should be governed, by which law they should be governed. So both these issues, substantive contract law issues as well as issues pertaining to arbitration, or all the issues which are governed in arbitration law, can be decided by the parties to be resolved by different laws. This is the strength of the party autonomy. Parties therefore can decide in which country they want to have arbitration. Now, if you are into litigation and litigation is filed in Mumbai, you have to contest the case in Mumbai. You have to contest the case in Mumbai. But if you decide in arbitration that the venue of your arbitration should be Malaysia, that in the time of Corona, we should not go to Mumbai courts. Or even after Corona, we think that Mumbai is very congested. We want a peaceful environment to resolve our dispute. Let's go to Thailand. So if I'm a very big shot person, I have a lot of money, why should I go to a poor courtroom with very less infrastructure? If I am Ambani, I'll prefer to resolve my dispute sitting in Taj Mahal Hotel. I'll prefer to resolve my dispute in Trident. I'll prefer to resolve my dispute in some good country, Thailand. That's the kind of convenience I want as a business community, as a person who is having a very great stature. So arbitration also gives this kind of flexibility, that you can decide in which country you want to resolve your dispute. It is not necessary because you are an Indian party, like litigation, you have to contest the case in India, or if you are an English party, you have to contest the case in England. No, you can decide in which country you want to have. So this is the strength of party autonomy, or this is the concept of the party autonomy. Parties are free to decide. Now, there is another concept in arbitration law, which we refer as the concept of the derogable provisions and non-derogable provisions. Let me again put the PowerPoint in front of you. Now, what are derogable provisions? Derogable provisions are those provisions which can be derogated by virtue of the party autonomy. Non-derogable provisions are those provisions which parties in exercise of their autonomy cannot derogate. That means, yes, you have party autonomy, you have wide discretion, but Indian Arbitration and Conciliation Act 1996, or for that matter, any law of any country which deals with arbitration, have certain limitations on the party autonomy. They say, yes, you have a party autonomy, but your party autonomy cannot extend beyond this point. I'll give you an example subsequently of this particular point, what is derogable provision and what is non-derogable provision. Then there are statutory safeguards. Now, generally, parties can decide for themselves. But there may be certain situations where the parties don't decide. In those circumstances, statute or the law provides a stipulation that in the absence of the party autonomy, statute should prevail. In the absence of the party autonomy, statute should prevail. Now, all these three concepts, party autonomy, derogable and non-derogable provision, and statutory safeguard, let me explain you by way of an example. I hope all of you can see this example wherein In front of your screen, section 10 is there. Now, section 10 talks about number of arbitrators. Now, it talks about the parties are free to determine the number of arbitrators. Parties are free to determine. Now, what is free to determine? This is called party autonomy. It is from here you can infer that under section 10, how many number of arbitrators should be there. It is decided, it is to be decided by the parties. And thus the parties have a freedom how many number of arbitrators they want. That freedom does not exist in litigation. If one judge has to decide, one judge will only decide. But here parties are free to determine. So this free to determine is the party autonomy. Provided that such number shall not be an even number. It means you can't appoint arbitrators in numbers like 2, 4, 6, 8, 10. It should always be an odd number. Like you can appoint 1 arbitrator, 3 arbitrator, 5 arbitrator. Thus, section 10 is bringing some kind of limitation on the party autonomy. So we can say this is a non-derogable provision. That while you have an autonomy, you have freedom to appoint as many number of arbitrators you want to appoint, but you can't appoint even number of arbitrators. This is called non-derogable provision. You cannot violate this thing by exercising your party autonomy. So now you must have understood what is non-derogable provision. Now let me tell you what is statutory safeguard. Statutory safeguard, so this saying failing the determination referred to in subsection 1, so this is subsection 1, this is subsection 2. So it is saying failing the determination referred to in subsection 1, the arbitral tribunal shall consist of a sole arbitrator. So clause 2 of section 10 says if the parties haven't exercised their party autonomy, under those circumstances, sole arbitrator, that is single arbitrator, must decide the dispute. So section 10 is one example where you can find operation of 3 fundamental concepts. First, the concept of the party autonomy. Second is the concept of the derogable and the non-derogable provision. You can't appoint even number of arbitrators. And third is the concept of statutory safeguard, that in case parties fail to decide something, then how should that issue be addressed, right? In that situation, law itself has contemplated, okay, the parties fail to decide, let me provide for that vacuum. Because generally parties may forget or they may leave it to the discretion of law. In that case, clause 2 of section 10 will apply and accordingly dispute will be adjudicated. I hope this is clear, these 3 concepts: party autonomy, derogable provisions, and non-derogable provision. Let me show you operation of derogable provision and non-derogable provision and party autonomy to a bit more extent. Give me a second. Where is my arbitration act? Now in front of your screen, we have Arbitration and Conciliation Act, BEAR Act. See, read language of section 3 here. It is talking about unless otherwise agreed by the parties. It means the parties have a freedom to decide. And if the parties don't decide, then clause A and clause B will apply. It means first there is a party autonomy. And if the parties don't decide, then this is statutory safeguard. Let me show you one more example of party autonomy. See section 11, appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. It means parties may decide what should be the nationality of an arbitrator. Okay. So, and if the parties do not decide that, say, arbitrator should be, if the party decide that the arbitrator should be only Indian national, then it will override clause 1 of section 11. In that case, only Indian arbitrator can be appointed. But if the parties do not decide, then arbitrator of any nationality can be appointed. So this is what we refer as an example of party autonomy. Let me show you one more example of non-derogable provision. Now, section 18 is an example of non-derogable provision. It talks about the parties shall be treated with equality and each party shall be given a full opportunity to present his case. Now, in any case, both the parties cannot decide in their contract that only one party shall get a right to present its case and the other party shall not get a right to present its case. That will be violation of section 18, which talks about equal treatment of parties. And therefore, violation of section 18 is non-derogable provision. The effect of non-derogable provision is, or violating non-derogable provision is, if an arbitrator decides a dispute by violating a non-derogable provision, then an award passed in such arbitrator can be struck down by the court. The court can refuse to recognize such kind of award and can set aside such award under section 34. Now, thereafter, there is another concept called doctrine of waiver. What is doctrine of waiver? Doctrine of waiver means the parties may waive some of their right. So, they can do so under section 4. One parties may waive their right to object. Say, in the beginning, I had an opportunity to question the appointment of an arbitrator, but I didn't question the appointment of an arbitrator. Under that circumstances, by operation of section 4, my right will be deemed to be waived. Now, subsequently, after that arbitrator has passed an award, I cannot challenge that the arbitrator was not competent to decide the dispute. Why? Because I had an earlier opportunity to question the jurisdiction of an arbitrator, but I didn't do that. This general principle has certain exception, which is not the subject matter of today's discussion, but very well we can discuss it at some other day. Then there is this concept of the judicial intervention. Now, one of the major reasons why Arbitration and Conciliation Act 1996 was passed was because it was felt that under 1940 legislations, courts were unnecessarily interfering at every point of time. There was too much of interference. And you all know that the objective of ADR is speedy resolution. The objective of the ADR is cheap resolution, means less costly resolution. But because of judicial intervention, repeated interference of the courts at the various stages of arbitration, the arbitration process was getting prolonged and delayed. And therefore, Section 5 of the Arbitration and Conciliation Act 1996 has provided that courts shall not ordinarily interfere. The court has the authority to interfere in the arbitration only in the specified cases. So it has a right to interfere in Section 8, where the concern of arbitrability is to be decided, but it has a very limited scope of interference. Under Section 9, for the grant of interim relief, court has a right to interfere. Under Section 11, after 2019 amendment, scope of interference of the court in appointment of an arbitrator has been marginalized. Now it is very, very minimal. Otherwise, the purpose of appointment of the function of appointment of arbitrator has now been delegated to the arbitral institutes like Mumbai Center for Arbitral Institute, or those states or cities where there are no arbitral institutes. In those cities, panel of arbitrators or a panel has been prepared by the Chief Justice of that High Court, and accordingly an arbitrator is to be appointed. So as far as appointment of arbitrator under Section 11 is concerned, it has been again reduced to very minimal, and there is not much interference. Then under Section 27, Section 27 of the Act talks about assistance of court in taking evidence. Now, arbitrator is not a judge. He does not have a power like a judge. So he cannot by itself order a party or enforce his order to the party to produce a document. So if I tell a party, bring the arbitration agreement, I can pass that order, but as an arbitrator, I do not have the power to enforce, because I do not have the backing of state machinery. So in those circumstances, either arbitrator or parties with the approval of arbitrator can approach the court and can take the help of the court in taking the evidence in case there is a party who is denying or resisting to take the evidence or give the evidence. Then under Section 34, we have provision relating to setting aside of award, where an arbitral award can be challenged on various grounds provided in Section 34, and court has a limited right to interfere. Similarly, under Section 37, there is a limited right to appeal. Now, this is what we call doctrine of judicial intervention. The doctrine essentially is that the court is not required to ordinarily intervene in the matters of arbitration except in the provided circumstances. Thereafter, we have the doctrine of competence. Doctrine of competence means an arbitrator has the authority to rule on its own jurisdiction. If one of the parties raise objection that an arbitrator does not have the jurisdiction, or there is no arbitration agreement, or the arbitration agreement is invalid, or the dispute is inarbitrable, then by virtue of the doctrine of competence, an arbitrator can decide on his own jurisdiction. So doctrine of competence reduces the dependence upon the court. Now, party is not allowed to go to the court raising the objection on the appointment of an arbitrator or his neutrality or the arbitrability of the dispute. They can refer the matter related to his jurisdiction or relating to the arbitrability of dispute to the arbitrator himself, and his decision will be final. But the implication would be, if he decides the dispute by virtue of doctrine of competence in not correct manner, in not legally correct manner, then same award can be subsequently set aside under Section 34. Then as per 2019 amendment, it has been provided that the arbitral proceedings must be confidential. Now, confidentiality is one of the important key aspects of arbitration. We do not have this concept of confidentiality in litigation, though we have to a limited aspect of in-person hearing or camera hearings, but they have different objectives. As far as confidentiality is concerned, what happens when two companies or commercial dispute is happening between two companies? If this matter goes to the knowledge of public, then the share value of that company can lower down. It can get affected. So it is purely business driven or economic driven perspective of looking at dispute, that if your dispute has become public, then the market of that company may go down. And therefore, let's maintain the confidentiality. And in this confidentiality, the people, the outside world will not get to know what is the proceeding, what is the award. We will decide amongst ourselves and will resolve the dispute. And this is one of the most important reasons why many companies, big companies, choose arbitration as a dispute resolution method. Third is impartiality and neutrality. Again, in 2015 amendment, to complement these concepts, we have added Schedule 5 and Schedule 7 in the Act, which are based on the red and orange list of IBC rules on taking evidence. IBC is International Bar Council. So International Bar Council has certain rules on taking evidence in which the principles of the impartiality and neutrality of the arbitrator are also expounded. Those are also one of the key features. An arbitrator, if he is not impartial or if he is not neutral, then his appointment or his mandate can be challenged and questioned under section 13 and 14 of the Arbitration and Conciliation Act. Now, let's look at the model arbitration clause. Okay, and this will help us in understanding. So when I said that the arbitration agreement should be in writing, let's try to understand what is arbitration agreement and how it looks like. So a typical arbitration agreement looks like this. This is a model arbitration clause under UN CITRAL, which is United Nations Commission on International Trade Law. So it provides any dispute, controversy, or claim arising out of or relating to this contract or the breach, termination, or invalidity thereof shall be settled by arbitration in accordance with UN CITRAL arbitration rules. So parties are saying that we will apply UN CITRAL arbitration rule. Now it is not mandatory upon them to apply UN CITRAL arbitral rule. They can very well avoid the applicability of these rules, but they decide in the arbitration agreement they want to be governed by these rules, they can very well do it. The arbitrator shall be appointed by both the parties mutually, so it has been provided. If this clause is not written in the arbitration agreement, then the section 11 of the Arbitration Act will come into picture if the parties are not able to appoint an arbitrator mutually. The number of arbitrators shall be 3. So section 10 will not come into picture. Parties, by exercising their party autonomy, have decided odd number of arbitrators. It's not even number. So statutory safeguard under section 10 will not apply here. The seat of arbitration shall be in India. So the seat means the word is used under section 20 is place of arbitration. But in a landmark judgment of Bhatia International versus Bulk Trading, which is the 2002 judgment, the court said that the term place in section 20 is equal to the term seat. In fact, the term place is used in two contexts in section 20. In one case, it is used as equivalent to the term seat, and in other case, it is used as equivalent to term venue. Venue can be any venue, you can decide any venue. It does not have any implication on the arbitration. You can decide venue to be Thailand, Switzerland, Mauritius, London. Does not have any implication on the arbitration. But when you decide a place as a seat of the arbitration, it means that the arbitral law of that country will apply. So if I decide that the seat of arbitration is India, then Arbitration and Conciliation Act of India will apply. If I decide that seat of arbitration is London, then the Arbitration and Conciliation Act of London will apply. If I decide that the seat of arbitration is, say, Thailand, then the arbitration law of Thailand will apply. So it is because of this reason in Bhatia International judgment, the Supreme Court held seat is the center gravity of the arbitration. Everything depends upon the seat. The lex arbitrae, that is law of arbitration, depends upon the seat of arbitration. Now, see, venue has been used in a different way. The venue of the arbitration shall be Singapore. You can have one seat. Seat is nothing but it will decide which arbitration law will apply. The venue can be something else. You can sit in any country and decide the dispute. But law of that country will not apply. Law of seat will apply. And you can decide upon which language. So this is an example of an arbitration agreement or arbitration clause under model law, UN CITRAL model law. Now let's move to model arbitration clause under, give me a second. model arbitration clause under institutional arbitration. Now we know that we have Mumbai Center for International Arbitration. So here it is mentioned that MCIA rules will apply. It has these ingredients. You can decide. It is for the parties to fill the seat of arbitration shall be. Parties may decide. They may decide India, England, etc. If they decide India, Indian law will apply. Arbitration law will apply. They may decide the tribunal shall consist of 1 or 3 arbitrators. So again, choice has been given. If both the parties want 1, they will use 1. Language parties can decide. The law governing this arbitration agreement. Now, the law governing arbitration agreement can be different from the law of arbitration. They can specify that law, and they can also, as I was telling earlier, you distinction between law governing the contract. That can be different. So this can be Indian law. The law governing arbitration can be, say, law of London, and the seat can be Paris. This is perfectly fine in arbitration. Accordingly, law of arbitration, Arbitration Act of Paris will apply. Law governing arbitration agreement, as far as issues pertaining to arbitration agreement is concerned, law of London will apply, and the respective rights and the liabilities of the party will be decided as per Indian contract law. This is very complicated topic, which is not a subject matter of today's discussion, but all of you must know at least in a very broad manner that this concept wherein we talk about different laws being applicable on the same dispute. Then how the process of arbitration looks like without the intervention of the court. At first stage, we talk about notice to arbitrate. So a party whom we refer as a claimant, so the party is not a plaintiff, like litigation. Here the person who is the aggrieved party is called as claimant. So claimant will send the notice to arbitrate to the other party. The other party is called as respondent. Now the respondent will reply, and if he agrees, then an arbitrator will be appointed. He can be appointed. There are two situations here. When notice to arbitrate is sent, already there is an arbitration agreement. If it is not there, both the parties can enter into arbitration agreement and can appoint an arbitrator. Thereafter, an arbitrator is appointed. This is not a prevalent practice in India, case management conference, but it is a prevalent practice in almost all the other jurisdictions of the world. Parties and arbitrators sit together, they decide how proceedings will be carried out, on which dates it will be carried out, what kind of evidence we will allow, what should be the timeline, so they can decide amongst themselves. Statement of claim is to be filed in 30 days. Statement of defense is to be filed in 30 days. We should not have oral hearing. We should have limited argument. So all these concerns, parties can decide in case management conference. Accordingly, an arbitrator will pass procedural order, which is also called procedural order 1. And he will say that the parties have agreed that the statement of claim should be filed in 30 days. Statement of defense should be filed in 30 days. Parties have agreed that there should not be any further, counter affidavit with respect to claim or defense. They may say that the oral hearing will be limited only. So accordingly, procedural order will be passed. After this procedural order is passed, like we have plaint in litigation, we have statement of claim. Like we have written statement in litigation, we have statement of defense here. After that, arbitrator calls the parties for the oral hearings, where the evidence is taken, examination in chief, cross-examination. You must remember at this time, Indian Evidence Act does not apply, or for that matter, any evidence law does not apply. Parties are free to decide which evidence law should apply. They may also decide no evidence law should apply. In that context, an arbitrator will accept the evidence based on his own reasoning and wisdom, after which there will be an arguments. And in arbitration, instead of the word judgment, we use the word award. An award is binding upon the parties. Unlike mediation, the final decision of the mediation is not binding upon the parties, but award is binding. And this is what the process of arbitration is without court intervention. If you have the role of the courts at the multiple stages, it gets extended. We can discuss it some other day. But that's it from my side for today about the fundamental concepts of the arbitration law. If you have any questions, please, you are free to ask. Otherwise, thank you so much. Have a nice day.
We have interaction session for 10 minutes. If anybody from the participants has any question, then can please ask.
Any participants would like to have a question? I guess none. Okay, Chandni.
No problem.
We will now request Ashwini Hiremat ma'am, Assistant Professor of our college, to propose the vote of.
There are questions in the chat, sir. Hello.
Yes.
There are so many questions in the chat, sir.
Can you tell me what are those questions?
Hello.
Yes. You are free to ask any question. You can ask any question. But don't type in the chat box, it's a bit inconvenient. You can open your mic, camera, so that I'm aware who is asking the question. I'll be happy to answer.
Hello, Brother sir. Please allow the participants to unmute.
Yes, sir.
Now the participants can unmute their mic and ask the questions.
Sir, good evening, sir. Sir, suppose if there is any party, the respondent has appointed the arbitrator, whereas the appellant was unable in a situation where the appellant was unable to appoint an arbitrator. In such case, the arbitrator along who is belongs to the respondent, can the arbitration can be continued, or shall he have to wait?
What's your good name? What's your good name?
Hello,
What's your good name?
my name is Pushpak, sir.
Yes, Pushpak. So, Pushpak, first of all, your question is technically wrong. The
Okay.
part of the arbitration would be claimant and respondent. The person who would appoint the arbitrator would be claimant, and generally a person who files the case will be the person appointing the arbitrator. Now, your question is if claimant unilaterally or without taking respondent into confidence proceeds to appoint an arbitrator. First of
Yes,
all,
sir.
it is not possible because arbitrator can only be appointed mutually. That cannot happen. They have to go under Section 11. So the claimant will file a case under Section 11 before 2019 19 amendment. If it is a domestic arbitration, arbitrator will be appointed by the High Court. High Court would satisfy itself that there is an arbitration agreement. Okay, there is an arbitration agreement. Whether the case is in the limitation period, yes, it's in the limitation period, appoint an arbitrator. If it's a case of international commercial arbitration, claimant have to approach the Supreme Court and the Supreme Court will appoint an arbitrator. They would see whether there is an arbitration agreement, whether the claim is time barred or not. And if not, the Supreme Court will appoint. But after 2019 amendment, that role has now been given to arbitral institutes. So the parties have to approach arbitral institutes who will appoint an arbitrator for them. In case there is no
Thank
consent.
you. Thank you very much, sir.
Sure.
Hello.
Yes.
Hello. Hello. There is a question from my side.
Please.
Sir, good evening. Hello, am I audible?
Yes, you are audible, ma'am. Please speak.
Yeah. See, sir, regarding the fees which is fixed for arbitration or arbitrators, this has been recently amended, and in the schedule it is being fixed and it is specifically mentioned. So while paying fees to the arbitrators, whether that schedule is followed, or is it regarding, according to the consent of the parties?
That schedule is to be followed. There is no reason why that schedule should not be followed. So the purpose of introducing that schedule is so that arbitration is not very costly. So what you are essentially talking about is the fourth schedule, which is enacted,
Yes.
the Arbitration and Conciliation Act. So this fourth schedule is to be complied in all the cases. But there are certain loopholes.
Yes.
There are certain loopholes in the legislation, because of which what happens, arbitrators, if the parties want to give extra money, by the consent of the parties, they can give extra money to the parties.
But as of the schedule mentions, the fees fixed is, it looks exorbitant. What is the observations?
No, in fact, as per arbitrators, the fees is peanuts. It is nothing. They were earning lots of money earlier. And
no.
Yes.
But while we looked at the schedule, it shows if the stake is below this much and the percentage that is to be given. So if we calculate according to that, it becomes more.
45,000 rupees.
Yeah, 45,000 for a. It mentions some basic stake. Yeah. Yes, and one more question I have, sir. Like you mentioned regarding the law which is applicable to the arbitration, and where they agree for the seat of arbitration, and that law will apply. And in case if an agreement is governed by or an agreement is to be governed by some other country, then that will apply. So there is a if the object is that the arbitration needs to be made very accessible and easy, and it has to be resolved easily, then why this complication?
This complication is because of the principle of neutrality. Parties from the different countries may not agree on the law of each other's respective nationality, and therefore they may say that okay, we will apply this law. So this is complete party autonomy. Second thing, they may not feel confident about the Indian contract law because they may see that it is a law which was enacted in 1872 and it does not satisfy the commercial interest. They may feel that the Singapore contract law is much advanced, recently revised, and we must decide our rights and obligations depending upon the contract law of Singapore. So these are purely commercial decisions, that by what way parties will advance their commercial interest. Because sometimes what may happen if the law is not proper, or if the law is not is very vague or does not define the rights properly, then the commercial interest of the parties may get frustrated. They may suffer huge losses. So it is their freedom which law they want to apply to their dispute.
Okay, thank you. One last question, sir.
Ultimately, it is their money.
Pardon?
Ultimately, it is their money, and they have to see how they can protect their money in a better way.
Okay, sir. And one last question regarding the enforcement of the award. In case of international commercial arbitration, if the parties are of different nations and if they were to enforce the award, then whose choice it will be?
See, there are various perspectives to it. Okay. Now the question is, in which country award is to be enforced? Okay.
Okay, yeah,
In
yes.
private international law, there are various principles. One of the important principle is choice of law principles, right? So
Yeah.
it depends upon variety of factors, but the most important factor is in which country you want to enforce the award. If you want to enforce the award in India, say in international commercial arbitration, then the Indian law will apply. Section 48 of the Arbitration and Conciliation Act will apply. It can be challenged according to that procedure, and it has to be validated according to the procedure given in Part 2 of our Act, and it will be enforced in the same manner. If the property is in Singapore, then the Singapore courts will have the jurisdiction to entertain any kind of objection on that award. A challenge may be raised, and if the challenge is successful, it can be enforced. And if there is no challenge, it can be enforced directly.
Okay. Thank you very much. Thank you.
Any other question?
Good evening, Mr. Chirag. First of all, grateful to you and thank you so much for such a wonderful session. Thank you so much from all of us. And my question is, what is the qualification required to be a specialist in arbitration as such, after the law degree is achieved and practice is done for some time?
I have already specified as far as qualification is concerned. It is not required that a person should have a law degree to become an arbitrator. This is one thing we need to keep in mind. Second thing, you have to distinguish between prior to 2019 amendment and after 2019 amendment. Prior to 2019 amendment, even I could be arbitrator, you could be arbitrator, any person could be an arbitrator, even second class student could be an arbitrator. What is required to become an arbitrator was parties' consent.
Okay.
Now, after 2019 amendment, they have inserted 8th schedule in which they have provided for the qualification and the and as per 8th schedule, now this 8th schedule which is inserted pursuant to section 43J of the Arbitration and Conciliation Act, though it is now in the textbook, it is still not in force. The part hasn't come into force. And therefore, various provisions which are mentioned in 8th schedule, that is, advocate should have 10 years of practice, chartered accountant must have 10 years of experience, post and work accountant must have 10 years of experience, member of an Indian legal service can be senior people, engineers, or managing directors of the public sector undertakings. All these people can become an arbitrator under the schedule created in section 43J. But because that law is still not in force, any person whom the parties decide can be an arbitrator. It completely depends upon their consent, their choice. But if you are going for an institutional arbitration, in institutional arbitration, what happens? Every institution has a panel of an arbitrator. The institution will be choosing arbitrator on your behalf from that panel. If you are having, say, a Singapore International Arbitration Center and you choose yourself to be governed by SIAC rules, then arbitrator will be appointed by the secretariat of the SIAC. They will tell you. Similarly, when you take the dispute in section 11, say in pre-2019 position, for the appointment of arbitrator to the High Court or the Supreme Court, then the High Court or the Supreme Court will appoint arbitrator from the panel which they already have. So they will appoint, say, a former High Court judge or a retired Supreme Court judge. That completely is on their wisdom and choice. You lose the party autonomy once you are not able to decide something mutually. But if you are deciding mutually, there is nothing which prohibit any party from appointing any person on this earth to become an arbitrator. Ultimately, it's purely commercial decision. It's my money, it's my dispute. Whom I want, whom I trust to resolve our dispute completely depends upon us. There are certain minimum requirements that the person should be independent, person should not have any interest in the subject matter, there should not be a case of collusion. Those are the public policy considerations which are not to be looked in such kind of inquiry.
Got it, sir. Thank you so much.
Thank you.
Okay, thank you, participants. It's time to propose vote of thanks. Ashwini Hiramat, Dr. Ashwini Hiramat, Assistant Professor of B.V.Bellad Law College, Belagavi, take this immense pleasure to propose vote of thanks. Firstly, I'd like to thank the resource person of today's session, Mr. Chirag Balyan, Coordinator Center for Arbitration and Research, MNLU, that is Mumbai University. Sir, I express my deep sense of gratitude to you. It was really an insightful lecture. I also thank you, sir. I also like to thank our beloved principal, Shri Dr. B. Jaisima, for his constant support and encouragement. Thank you, sir. Next, I'd like to thank both the coordinators, Srinivas Palkonda sir and MS Alapnavar sir, for their efforts. Thank you, sir. Next, I'd like to thank all the teaching staff for their kind support. And I also like to thank the our student Ramkrishna Nayak, who helped us technically to make this webinar a grand success. And lastly, I want to thank all the persons who directly and indirectly helped us to make this national webinar a grand success. Thank you one and all. Thank you, sir.
Thank you so much. Thank you. Can I leave?
Yes, sir.
We'll wind up the meeting.